Good morning, everyone. I'm Mike Mello, editor of Providence Business News and the moderator for today's virtual summit on the coronavirus stimulus programs. We're glad you're able to join us this morning as we attempt to break down the federal and local stimulus programs for small businesses and nonprofits to see how you can take advantage of them. You can't see me on your screen because we wanted to reserve the space for the panelists. In lieu of payment for this virtual summit, PBN asks you to consider supporting the COVID-19 Response Fund, established by the Rhode Island Foundation and United Way of Rhode Island to support nonprofit organizations providing direct assistance to Rhode Islanders with financial need or demonstrable hardship resulting from COVID-19 and not otherwise covered by other resources. You can visit rifoundation.org for more details. Now I'd like to acknowledge and thank our sponsors for their support of today's virtual summit. First, our presenting sponsors, Rhode Island Foundation and Rhode Island Commerce Corporation. And our partner sponsors, HR firm Insperity and law firm Pierce Atwood. Thank you all for supporting the conversation about the most important challenges facing businesses in our state. We're happy to have with us this morning Stephen Pryor, who serves as Rhode Island's first Secretary of Commerce, appointed by Governor Gina M. Raimondo in 2015. Secretary Pryor oversees and coordinates the state agencies and offices responsible for economic development, business regulation, housing, and workforce development. Stephen, are you with us?
I'm right here.
Good morning.
Good morning.
Turn it right over to you.
Mike, thank you so very much. We're so grateful to PBN for your service at all times to the Rhode Island business community. Your readership appreciates you every day and every time you issue your weekly, but also at this very important moment in time, we're especially grateful for the news outlet that you represent, for the insightful analysis and reporting that you all do about the state of business in Rhode Island. This is an enormously challenging time, and we acknowledge and we are fully cognizant of the fact that businesses are struggling. This is unprecedented what's occurring here, and we are so grateful for the resiliency and for the creativity of businesses that are working through these problems and that are innovating in order to adapt and survive through this very difficult period. I bring greetings on behalf of Governor Gina Raimondo. The governor is so proud of the businesses of Rhode Island and so pleased to see the ingenuity that you all are exercising and the resolve that you are demonstrating in the midst of all this. We are very pleased in this particular case that in lieu in payment for this virtual summit, PBN is asking you to consider supporting the COVID Response Fund. I agree with you, and I'm so pleased that you have stepped up, and I want to reiterate what Mike has already said about doing that. The couple of things I want to touch upon are these. There is assistance out there through the Small Business Association. We are so impressed with Mark Hayward and the tireless efforts he's made. We've called him and he's called us at all hours. And Mark has been a tireless advocate for us. The PPP program and the EIDL program, that's the PPP and the EIDL program, are forms of small business assistance that are especially noteworthy and of value. We recommend that businesses that haven't yet apply swiftly, that you stay in touch with your lenders if you're seeking PPP funding, and that you stay in touch, quite frankly, with Director Hayward and his office, who are just terrific partners. We look forward to hearing more from Mark today about the possibilities expressed there, the possibilities regarding the programs. And I want to let you know also, the governor is every day in touch with the congressional delegation, and for that matter, with the federal administration on the necessity of expanding these programs. We have done our best at the Rhode Island level to ensure that there is access to resources that especially small businesses need to survive through this. And I want to just take note of a couple of points. The Rhode Island Commerce Corporation has set up a bridge lending program that bridges to the EIDL, Small Business Lending Program of the SBA. And that program enables a company to receive up to $5,000 if it is 1 to 10 employees or a restaurant. And we're very pleased with the receptiveness that businesses have had to that, and the rapid applications that we've received. There have been over 162 businesses that have already gotten cash in their hands through our micro lending program, that $5,000 bridging program to the SBA's program. 91 more will be funded in the coming days. There are still some available slots for that bridge loan product. If you want to see if you can receive dollars even faster than the EIDL program in particular, the Economic Injury to Disaster Loan Program in particular. I also want to note that something else the Commerce team has established and launched in recent weeks is a new method of receiving tech support. That is to say, if smaller businesses want to receive tech support from some experts, some local companies and some national companies that have an operation in Rhode Island and are tech experts, Rhode Island small businesses can reach out and obtain those services. It's about establishing perhaps a first-time digital payment system online, a better online presence more generally. All of these things are possible. There have been over 120 sessions arranged under this program, over 120 instances where businesses have already availed themselves of these supports. And we had a business, for example, that had no ability to sell online. They had a session with a commerce representative, Suli Ko, who's been a magnificent orchestrator of this work for us, to set up kind of an electronic store. There was a session with a marketing expert, partly to make sure that the company was at the top of the list in Google search results, search optimization for that particular company. Frankly, with the United States Postal Service, there was a session set up to make sure that there were shipping services and discounts that were arranged. So you can see the services range from the digital to the more practical and even more traditional, and they're up and running. We had another store that signed up with Upserve, our own homegrown Rhode Island company that is an electronic payment company, to get online, and they got online within 48 hours. So I'm not naming the names of the smaller businesses because they should reveal themselves if they ever wish to in these particular cases. But they assessed their own vulnerabilities. They knew that they needed to move to establish an online presence or enhance it, and they did it. And this has happened 120 times, and I encourage others to step up and do the same, or to just contact us and do the same. 521 HELP is the way to reach Commerce. It's an easy way to leave a message or reach a person and get some information rapidly. And you can always check our commerceri.com website, commerceri.com, to find out more about these particular services. We also link to information on the SBA loans. We have information on the executive orders as they roll out with clarifications and additional information. So it's a good one-stop for you to visit commerceri.com. A few other quick points. So impressed with how agile Rhode Island companies are in the midst of this crisis, and how many are pivoting in order to contribute to the economy and to the relief efforts. So just a couple of points here. On the question of masks, I'm going to talk a little bit more about the masks policy before I'm done. But on the issue of masks, listen to the companies that have stepped up to produce masks for Rhode Island and for the nation. Honeywell in Smithfield, Envision Solutions in Cumberland, Cooley Group in Pawtucket, Propel in Pawtucket, Northeast Knitting in Pawtucket, G-Form in Smithfield, all are producing face coverings in some way, shape, or form. Some of them are running short at this point, and there are some delays, admittedly, but that's in the sense of promoting these companies a good thing. I'm going to talk more about the whole mask issue to clarify some things. On the subject of hand sanitizer, listen to these Rhode Island companies that have stepped up. White Dog Distillery in Pawtucket, Industrious Spirits in Providence, Sons of Liberty in North Kingstown, Aiden Scientific in Woonsocket, JB Pharmacy and Compounding in Warwick. So proud of these companies. We are so proud of them that they've pivoted and they're keeping their enterprises afloat while helping Rhode Islanders in these key ways. And on the procurement front, we're looking nationally, even internationally, to procure PPE, to procure needed ventilators for our hospitals. And these companies have stepped up to help us source, even if they're not the producers themselves. Contact Medical of Providence, Amgen, Quonset, more generally, has undertaken incredible work along these lines. I'm just so heartened by this. We know that these times are extraordinarily tough, and we know that the requirements continue to be restrictive. But to give you a broad view, other jurisdictions in the Northeast and other coronavirus affected jurisdictions in the US have closed more sectors than we have in pursuit of health and safety. We have ensured that under Governor Raimondo, we're undertaking rigorous restrictions and establishing important rules to ensure health and safety, but other jurisdictions have shut down more. I'll give you a key example: manufacturing. So we have not undertaken an effort to draw a bright line between essential and non-essential manufacturers and shut down non-essential manufacturers, quote unquote non-essentials. We, Rhode Island, are the birthplace of the Industrial Revolution. We have a vibrant manufacturing community. It's a well-organized community with the Rhode Island Manufacturers Association being a terrific industry association. We've worked closely with them to ensure that we have safety measures in place and guidance in place that will enable manufacturers to rise to the occasion and keep their workplaces safe so that they continue operations. To be sure, we have to continuously evolve and refine, no doubt about that. And to be sure, there are individual instances where there need to be significant revisions in a plant's operations. But the RIMA organization has set forth a pledge that lays out the guidance that will enable a manufacturer to operate safely and with health in mind. And many manufacturers across the state have signed on. We just did a statewide conference call with manufacturers yesterday to make sure that all these points are clear. You get the idea. So we have shut down fewer businesses and we've kept open certain sectors in order to enable our economy to remain as healthy as it can be in this context, and to enable the reopening to be a less abrupt phenomenon and to occur more effectively when the time does come. I've alluded. So
can I jump in quickly, Stefan? I'm sorry.
Yes, please.
Will you be able to stick with us for a couple of minutes through some of our questions with the panelists?
Yes, definitely. Yes, I will.
All right, terrific. So we want to get to that quickly. So if we could jump to that, I'd appreciate that.
All right, no problem. Let me say this couple sentences on masks in that case, because I don't want to be elusive on the point. A couple days ago, Governor Raimondo rolled out a face covering policy. To be clear, that policy applies across the board to employers in Rhode Island. So that's customer facing retail and restaurants, that's manufacturing operations, that's offices of all descriptions, that's construction, that's all industries and sectors. The idea is that face masks should be worn whenever an arrangement cannot be made where a 6-foot distance can be maintained between employees on an easy basis, on a defined and measurable basis. You can see the executive order on the Commerce RI website. If there are problems you need to solve, if you have scenarios that where health and safety of workers could be impacted if masks were to be worn, please contact the Department of Business Regulation and they can help you. The policy pertains to cloth face masks, meaning that these can be do-it-yourself style, they can be bandanas and scarves. They need not be professionally made and manufactured masks. So please let us know if there are instances where you need to have a conversation, and we hope that our responsiveness will enable you to implement this policy and all other policies well and without too much difficulty.
Terrific.
Mike, I conclude and I turn it back to you.
Thank you, Stefan, not only for joining us today, but really for what you and Commerce RI do every day to keep as many Rhode Island companies active and operating as possible. Really is the first step in any recovery. So thank you very much. Now I'd like to quickly introduce for everyone this morning's panelists. First, we have Doris Blanchard, Assistant Director of Supply RI for the Rhode Island Commerce Corporation. Doris manages the Small Business Assistance Program and supports the Senior Economic Development Advisor on special projects and innovation ecosystem initiatives in Rhode Island. An accomplished economic development, public affairs, and community relations professional, she is the liaison for Commerce RI and the RI Alliance for Business Resilience. She's the recipient of the Small Business Administration's 2011 RI Financial Services Champion of the Year Award, RI College Alumni Award, Cesar Chavez Award for 2013 for Community Leader, and the Extraordinary Women's Award 2010 in Business Development. Doris is a board director of United Way of Rhode Island and serves as a coordinator for the Latina Leadership Institute. Next is Stephen Del Sesto, a partner at Pierce Atwood LLP. Stephen focuses his practice on corporate restructuring, state and federal insolvency proceedings, creditors and debtors' rights, civil business litigation, and general corporate matters. Stephen is the only SEC-approved receivership attorney in the state and has regularly served as a court-appointed fiduciary for federal and state courts in Rhode Island and Massachusetts business disputes, Securities and Exchange Commission actions, fraud investigations, and insolvency matters. He has advised various businesses on issues related to phases of formation, growth, and sale, has been appointed by the Chief Judge of the Rhode Island Federal District to investigate and oversee the liquidation of assets in a multi-million-dollar Ponzi scheme. Next, we have Mark Haywood. Mark joined the U.S. Small Business Administration's Rhode Island District Office as Deputy Director in 1991. In 1996, he began serving as Acting District Director and was appointed District Director in 2000. He has served on several occasions as Acting Regional Administrator for New England, and has also served as a Senior Advisor to the 25th Administrator of the SBA, Linda McMahon. Next, we have Gina McDonald. As a CPA and lead consultant at Fiscal Management Associates, Gina works closely with a variety of nonprofit organizations to assist in creating their internal fiscal capacity. She is part of a team dedicated to building long-term client relationships and providing one-on-one services customized to each organization's needs, finance department support. As the rules and regulations for accounting and reporting evolve and become more complex, Gina stays up to date on the changes, translating regulations into relatable terms, guiding organizations in continued compliance. Prior to joining FMA, Gina spent 17 years in public accounting, including 10 years dedicated to nonprofit and governmental accounting and financial reporting as an audit senior manager. And lastly, we welcome Kelly Yates, Vice President of Service Operations at HR firm Insperity. Kelly has more than 20 years of experience in the human resource industry and is currently the Vice President of Service Operations at Insperity. She specializes in employee relations, workplace investigations, and resolving EEO-related employment complaints. Kelly has a Master of Business Administration from Wayland Baptist University and a BA in Economics from the University of Texas, and she is also a certified compensation professional and SPHR certified. We welcome you all, and thank you very much for being here today. Now, I have different questions for each panelist, but I encourage any of the panelists to weigh in if you have something to add to a comment or statement from fellow panelists. We really encourage that type of conversation and dialogue among you. Also, for our audience, you'll also notice a program in the handout section with the topics we intend to cover this morning. If you have a question for the panel, please type it in the question box. We'll try to get to as many questions as possible around 10:45. So let's begin. First question, we can start with Mark. A national monthly survey of small business optimism conducted by the National Federation of Independent Businesses since 1986 saw its steepest decline in the survey's history in March. About half of the respondents said they could survive no more than 2 months under the conditions they're facing. Even with the financial aid packages approved by Congress, how much longer can small businesses survive with most or all of their operations shut down? Mark, we'll start with you.
Yeah, that's a tough question to answer. I mean, it's clearly, you know, we've been talking to a lot of small businesses across the state. As you all know, I'm also the interim director in Connecticut, so I'm doing both states. And everybody is trying to juggle as much as they can. Right now, the Paycheck Protection Program really is the product for them to try to at least get over the next 8 weeks. And as we see loans closing and funding going out and people coming back on the payrolls, even if, and the concept of small businesses actually paying somebody to stay home is a little bit unique, to say the least. And I think a lot of people are having some trouble getting through that idea. But we're working with each of these businesses. It's our hope and prayer that by the time we get to the end of the 8 weeks, that these businesses will at least be back open and revenue will start coming in through the door. In the meantime, that's what all of these programs are about. They're basically to help small businesses mitigate the negatives that they're currently working with.
Okay, thank you. Stefan, do you have some thoughts on that? You still with us, Stefan?
Yeah, can you hear me?
Sure can.
I'm afraid I need you to repeat the question for me in that case.
Yeah, I get the question, I guess, is just, you know, how long can small businesses really survive with all of their normal operations or most of their operations shut down?
Yeah, I mean, I think the reality is that it can't go on interminably, and the answer I would give you is that Governor Raimondo's working on a reopening plan. So the objective is to track the health data that are being assembled across various work streams in the state government, and to determine when and under what circumstances partial phased opening can begin. The reason I'm answering in this manner is to say that we recognize it can't go on forever, and we do need to figure out a time in the foreseeable future when we can begin at least a partial phased reopening. The details of that are yet to come because they're still in formulation.
And she's been quite candid, I know, during her daily briefings. I mean, it's a moving target. I know she said as recently as a week or so ago, she hoped it was weeks and not months. But is that still the commitment, or is it, we can't even say that now?
I'm not going to preempt the governor on the expression of a timeline, but I can tell you that we are actively working on the subject.
Terrific.
Mike, if I could,
please.
If I could jump in a little bit here too. You know, obviously all businesses are different. So what one business may be able to do to survive for the next few weeks or 2 months may not be the same for another. And this is obviously I think would probably be considered a last resort for a lot of these businesses, but both the federal court with the new Chapter 5 reorganization, as well as the Rhode Island Superior Court Business Calendar just rolled out a non-liquidating receivership program where businesses that are only insolvent or experiencing financial difficulties right now because of the coronavirus and the shutdown can go to those courts and seek some relief, where they can get their hands around, with the court's assistance, their debt, how to manage it, and maybe even tap into, in addition to the various assistance that state and federal government are providing, but maybe third, I'll call it like third tier lenders, more private lenders who are willing to put up cash and assist in the reorganization. So those efforts are also in place right now because nobody knows how long this is going to go for.
Thank you. Any other thoughts on that? Okay, we can move on to the next question. Maybe we can talk about some of the details and the key provisions of the $350 billion forgivable loan program, which is reportedly already near its lending limit. Who is eligible and how can they still apply? And Congress is also considering another $250 billion for small businesses. Are the key provisions and requirements for that aid package expected to be the same? Mark, maybe we can start with you on that.
Well, I'm certainly not going to guess as to what is or will not be the same. I can only deal with the facts. And the facts are what we have for the Paycheck Protection Program right now. I can tell you that I just looked a couple of minutes ago, and we're over 8,700 loans here in the state of Rhode Island. I would suspect that we're probably at $1.3 billion to small businesses, which is pretty substantial. But I'm not going to suspect or try to even imagine as to what, if any, changes would be forthcoming if there is a next tranche. But basically, we're still funding. We were still funding 5 minutes ago, so that means that money is still available. And we will continue to fund until such time as that we reach the maximum level that was appropriated by Congress, and at that time the funding will cease. The bottom line is any small businesses that are under the SBA size standard, and even some businesses that are over the size standard that have multiple businesses that are on NAICS code 72, certainly, which is hospitality for the most part. And with the alternate size standard, there's not a lot of businesses here in Rhode Island that would not qualify for the Paycheck Protection Program. In the same vein, 501c3s as well as 501c19s, which are veteran organizations, and tribal businesses are also eligible. And I know for a fact, having looked through a lot of this, that they have been applying. And I think that we'll continue to not only fund loans, but also, and the lenders are doing an unbelievable job. It's just incredible to see the amount of effort that they're making, not during the work hours, but at all times of the day and night, where they're just inputting applications into the system. And I think it's been very impressive. And I will tell you that from my perspective, what I see, and I went in this morning to look to see which lenders were funding, and it's basically community banks and a lot of the local lenders.
Mike, can I jump in here for a second?
Please do.
I want to preface this by saying yet again that Mark Hayward is doing a phenomenal job on behalf of Rhode Islanders, and we're very grateful for his partnership and advocacy. We think it's essential that Washington re-up with the PPP program. That is to say, it's essential that Congress and the White House replenish the PPP fund when it runs out. The public reports are that the $350 billion allocated for the PPP program are being exhausted and may in fact be all done imminently. The reason I mention this specifically is that because of the complexity of rolling out the program, some banks were not able to get off the starting line when it was nationally initiated. They started perhaps a day or two later, maybe more. There are So there are individuals that are in the queue with such banks that may be of no fault of their own behind and may not get approved by virtue of their bank's starting timing. In addition, there are business applicants that are that have been unbanked to date, and these unbanked businesses had to work hard to find a place with which to apply. They may not even have found one as of yet. Some applied through our Goldman program, which took in a great number of businesses very rapidly. So all of this to say, it's essential that Congress and the White House re-up this program.
Thank you. Mark, do you know for those applicants who are in the queue, once the lending limit is hit, are they at the front of the line if there's another aid package that's approved? Or?
I don't. In fact, what we were told was once the money runs out, there will not be there will be no ability to input that information into the system to create a queue.
Okay. Any other thoughts on this?
No, lenders are going to, hold the applications, and we'll see what happens. I know that in talking, I was on a call yesterday with Senator Reid, Senator Whitehouse, Congressman Cicilline, and Langevin. They mentioned PPP along with other programs, and it's just a matter of we cannot go beyond the appropriations that we've been provided. And at some point in time, it appears today we will cease to have any additional appropriation.
Perfect. Mark, we'll stick with you on the next question because you touched on this already. You gave some of the updated Rhode Island numbers for applicants and amount of money approved for forgivable loans through Paycheck Protection. Can you say how many other Rhode Island-based businesses have applied for and received COVID-19 related loans through other programs administered by the SBA? And also, I was just saying also, do you feel
updating? Go ahead. Sorry.
You can say also, do you feel Rhode Island businesses have gotten their fair share so far through the various programs?
I think 1.2, 1.3 billion to Rhode Island is a significant amount of money. I'm not, I mean, the fair share, that's a judgmental question, and it's just all I know is that Rhode Island is certainly at the forefront, and clearly people are inputting information into the system in order to be able to get approvals so that Rhode Island businesses can get Paycheck Protection Program loans. On other loans, unfortunately, the systems are not being updated. As you can see, a lot of that has been, I mean, when I look at the system on the Paycheck Protection Program, I'm actually going in and looking at it in real time, so I know what's being inputted at that particular time. But the regular reports are not being run, so I really don't have any other information other than just prior to this. I think there were 58 economic injury disaster loans that were approved, but I'm not sure as to what the status is now because that has not been updated since April the 8th.
Okay. Any other thoughts? Mark, can you just briefly explain for people who might not know the difference between the economic injury disaster loans and Paycheck Protection?
Yep, economic, and let's talk about the long-term economic injury disaster loan. That really is put in place for long-term working capital to help the businesses get back up and running. The Paycheck Protection Program is exactly what it means. It's for you to bring back your employees back onto your payroll and for you to work with those employees, even if they're sitting at home, over the next 8 weeks to ensure that they're paid and they come off the unemployment rolls, and with hopefully within that 8 weeks, the economy will begin to reopen and we will be at a position where things will continue to roll. The economic injury disaster loan is really looking beyond those 8 weeks and beyond the next few months to the 8 to 12 months. And there are a significant number of loans that are in the queue there as well. The authority is extremely limited. The CARES Act provided for $10 billion, I believe, in what they call EIDL, or Economic Injury Disaster Loan Advance. And the agency made a determination that, excuse me, that would be $1,000 per employee. And I know a lot of people said, well, it said 10,000, but it said up to 10,000. Again, I don't make the rules. We only tell everybody what's happening. And basically, I'm assuming that both of those programs are going to be pretty much exhausted. The EIDL itself was not, there was no appropriation in the CARES Act for that, but I do know that and yesterday on the call that I did with the members of Congress, they all mentioned about the need to refund that particular program. So, but again, you know, we can only do what authority we have, and we have to wait for Congress to make additional moves.
Thank you. Doris, I'd like to come to you first on this next one. What other
Sure.
initiatives is Commerce RI working on that employers should be aware of? Also, are there any specific efforts directed toward Spanish-speaking and entrepreneurial communities?
Absolutely. Thank you, Mike, for the opportunity. So we at Commerce have been working a lot of hours at, taking care of our small businesses, whether they're, large businesses or small businesses. Calling the helpline, like Stefan mentioned, 401-521-HELP. We have been working every day, working with the SBA and all our resource partners, working for all our businesses, providing information. Our website is bilingual. Every day we provide updates in English and Spanish about all the executive orders or about our initiatives, our programs like the bridge loan, technical support, and everything is bilingual. I have been appearing virtually every day to Spanish-speaking media. Also, every week we have been providing info sessions in Facebook Live, partnering with the Small Business Development Center, with SEG, with the Center for Women Enterprise, Progreso Latino, and the Rhode Island Hispanic Chamber of Commerce, providing information because, I know it is a very difficult time, especially for small businesses. And I have been providing a lot of information. As you know, every day this information changes and they may get confused especially about applying for the different types of loans. So we have been providing a lot of information in different ways, through the social media, and answering a lot of calls through our hotline. So I get in the queue a lot of calls, and we get back to them. Just to give you an idea of how many calls we have received, a total as of yesterday, 2,626 COVID hotline calls. A lot of the requests are, on access to capital, workforce, the Department of Labor and Training information about our own bridge loans. They need an explanation about the governor's executive orders, and also, concerns about the things that are happening in the state, on COVID-19. So I can just say that, we have been partnering with a lot of our, SBA resource partners to provide information as much as we can to our Latino community and our minority community, because, they are the ones that need more information. They get confused. They cannot afford an attorney or a CPA to provide them with that information. So as much as we can, we provide them with those resources that we can.
Thank you. Any other thoughts on that? Gina, I'd like to start with you first on the next one. How can the 50% refundable payroll tax credit on worker wages incentivize businesses and help retain workers?
Sure. So this is another part of the CARES Act. It's really called the Employee Retention Credit, and it's generally available to businesses whose operations either are fully or partially closed due to a government mandate, or if your gross receipts have declined by more than 50%. And of course, there's a really specific way to measure that decline. We do see a continuation here, though, around the theme of the stimulus package, really focusing on providing dollars for payroll and retaining our employees. And really what it boils down to is a maximum credit of $5,000 of payroll paid per employee of a business over the course of calendar 2020. And businesses who would qualify for this and have eligible wages, the way they would take advantage of that credit is actually by not having to remit withholdings and certain other employment taxes to the federal government. So when you can take advantage of the credit, it does help cash flow pretty immediately.
Okay. Any other thoughts on that? Jeter, I'd like to stick with you for the next one first as well. So what does the delay in employer side payroll taxes for Social Security until 2021 and 2022 mean for companies?
Yep, absolutely. So again, another provision in the CARES Act, again, really designed to help us with our cash flow. It allows businesses to delay payment of the company paid portion of Social Security tax. So you may be aware that we as individuals pay this tax on our wages, but employers match that tax as well. So it's 6.2% of most wages. And we can take advantage of this starting now. We're able to hold back paying the feds that tax. So we can do it in quarter 2 of 2020, quarter 3, quarter 4, for all of calendar 2020. If we take advantage of that deferral, so it's not a forgiveness, we'll have to pay it eventually, but it's a way for us to keep cash in the bank right now and pay it later on. Whatever we end up deferring as businesses for that tax, we will have to make 2 repayments to the feds, or 2 payments to the feds. First payment by the end of 2021, and the second half of that payment of the taxes that we held back on by the end of 2022. So we have a bit of time to catch up on those payments. There is no penalty, nothing like that, for taking advantage of that. So again, it's another way that we can try and manage cash flow and hold on to some of our money for paying other expenses that are coming up.
Thank you. Do you have a sense of how aware businesses are of these provisions? I mean, do you think it's something that a lot still are not aware of?
Yeah, good question. I'd like to hear what others are hearing as well. I feel like we've already heard now, say, of 4 or 5 different opportunities. And I think what's happening is folks hear of these opportunities, but wonder, does it apply to me? How do I take advantage of these opportunities? What's the mechanism? How do I put all of these opportunities together? Because there are some provisions that say, if we were awarded a PPP loan, we would not be eligible for the first thing that I talked about, which is the employee retention credit. How does it interact with what we just talked about in deferring Social Security taxes? Could I do those 2 at the same time? So what we're hearing is folks really needing help in figuring out, how do I put all this together? How can I take advantage and craft this strategy, or I take advantage of as many things as possible, but I don't combine programs that are not eligible to be combined? It's a little confusing to navigate.
Right. Any other thoughts on that? Okay, Stephen, I'd like to start with you on the next one. What are some of the other issues that employers need to be mindful of regarding tracking use of funds under the PPP loans to comply with the 75-25 restrictions?
Thanks, Mike. Well, that's an important issue, because obviously the money that's coming in on the PPP loan is essential to assist those businesses over the 2-month period. But what a lot of my clients and my colleagues and the business group's clients have been asking about and are concerned about is the forgiveness of the loan and what might jeopardize that forgiveness of the loan, or the portion that could be forgiven. And so, the easiest way, and actually what we have felt the simplest answer is if you do not have a dedicated payroll account that you can deposit those monies into, where you know that they're being used for purposes that they are intended under the Act, the recommendation is to open up a segregated account. You need to track those expenses. There's the 75-25 threshold, where 75% need to be directed towards payroll and related expenses. And the easiest way, it's a very confusing time for a lot of people. They're doing things and trying to pivot in ways that they've never had to and never thought they would have to before. And the last thing they need to do is worry about whether or not they went slightly over that percentage and then disturbed what forgiveness they might have been able to take advantage of on those loans. So those are the types of things we're doing. Is you need to track them. You need to track them carefully. There's going to have to be some documentation provided. And the best way to do that is to keep it as separate as possible so that the tracking is easy. Don't commingle them with other operating funds or things like that. Either keep them in a dedicated payroll account, or if you don't have one of those, set up a segregated account so you can track them more easily.
Thank you. Any other thoughts?
Yeah, a
Please.
couple. First of all, Steve is correct as to please keep good records as it relates to the PPP program. But the other statement is, yes, it's a minimum of 75%. It's not a maximum of 75% that be spent on employee payroll and benefits. I mean, if an owner decides that they want to spend 100%, that's clearly within their jurisdiction to do that. I think what it says is basically there's a minimum that has to be spent on payroll and benefits. And we've talked to multiple employers that have said, well, I want to spend more. I want to retain my employees. They've been here for 20 years plus. So it's important to understand that. We can't require them to have a segregated payroll, but I think the CPA and accounting community has been, for the most part, encouraging them to keep them separated so that the accounting on the backside will be as easy as the accounting. Because remember, this is an assertion of the business that they have spent this. They're going to need 941s and other evidence to prove that, but just make sure that you have good accounting.
Thank you. Any other thoughts?
I have a quick, just another thought, and I don't know that we would have time to dig into this, but if we do, maybe at the end, another consideration around the forgiveness that we've heard a lot of questions starting to come through about is around the requirement to maintain the FTE count. So first, making sure we're segregating funds, keeping track of the expenses, they're eligible. Then part two, maintaining our employee FTE count as the two components for forgiveness. So those are really where we're hearing a lot of questions is around that as well.
Thank you. Kelly, I'd like to come to you first on the next one. So what are some of the new employment provisions, including emergency paid, sick and family and medical leave, that employers need to be aware of?
Thank you. Good morning. I'd like to share some slides just because there are some details to cover here in the leave. So I will pull this up here. Okay. Should be seeing my slide deck there. Does that work?
Well, maybe you can sort of give a response there and we can see if we can get the slides up as you're going.
Yeah, definitely. Yeah, so I'm sure we've all heard about the Families First Coronavirus Response Act that became effective on April the 1st, and it does provide for two different types of paid leave under the program. I'm going to, let's see. Here we are. I think this is coming up. How is that?
I'm not sure we can all see the slides right now, but I just do your best to work. Oh, coming up now.
Excellent. Slides on the screen. Okay. So the Families First Coronavirus Response Act applies to businesses that have less than 500 employees. So that's a key factor there. And then it provides, like I said, the two types of paid leave, and it allows for tax credits. So employers should not have to incur any out-of-pocket expense. And it does permit for some exemptions for smaller employers. So see if we can move this along. So first, let me talk about the emergency paid leave, paid sick leave component of the Act. And this requires employers that are subject to the Act to offer employees 80 hours of paid sick leave, and that's for situations that involve a quarantine or if the employee is seeking a diagnosis or preventative care for coronavirus, or if they're taking care of a child. And there's a maximum amount of $511 per day, up to a maximum for those 10 days of $5,110. Under the emergency expanded FMLA, employees can take a total of 12 weeks of job protected leave if they're unable to work due to one reason only, and that is to care for a child whose school or child care provider is closed as a result of the pandemic. And that gets a little confusing on the details, but basically the first 2 weeks of that 12 weeks is unpaid, but it can be covered by the paid sick leave that we just talked about. The additional 10 weeks of paid leave is paid at 2/3 of the employee's average pay, what they would regularly receive, up to $200 per day with a maximum total of $10,000. And just a quick recapture of that information, the difference between the two. The paid sick leave is up to 80 hours for full-time employees. For part-time employees, it's what they were would have worked in that 2-week period on average. So easier if you have a longer-term employee. If you have a newer employee, you'll have to go by what you would have scheduled that person for a 2-week period. It's full pay, and we'll talk about the conditions for the full pay versus the 2/3 pay. There are 6 covered reasons, and employees are eligible on day 1 of employment for this emergency paid sick leave. So you could hire someone today and they have a qualifying reason and you would be required to pay this sick leave. The emergency FMLA is those 12 weeks that we talked about from days 11 through 60. And there's only one reason that the employee is unable to work due to the lack of childcare or school for the child. And that is for eligible full and part-time employees who have been on your payroll for a minimum of 30 days. So lots of details to remember there. As I mentioned with the emergency paid sick leave, there are 6 reasons that an employee can take that leave. Reasons 1 through 3 that you'll see here on the screen are paid at 100% of the employee's regular rate. And so basically those are reasons for the employee's own health condition. So they're under quarantine or isolation. They've been advised by a healthcare provider to self-quarantine, or they're experiencing symptoms or trying to seek a diagnosis. And those are paid at 100%. The reasons 4 through 6 are paid at 2/3 of the regular pay, and that is if the employee is caring for someone else that's under quarantine, a child, or is experiencing any other similar condition specified by the Secretary of Health and Human Services.
It's just an incredible amount here for employers to get up to speed on. I would just ask you regarding the FMLA, who pays that? Is it the employer?
The employer pays that, and then we'll talk about how that is that's applied toward their payroll taxes. So in most situations, the employer should be able to immediately offset that with the credit against their payroll taxes. If not, they do. There is an accelerated way that they can receive that reimbursement from the IRS. Definitely. So we talked about just the one reason. I think this is a big point of confusion on that 12 weeks of expanded FMLA. It's only if the employee is unable to work or to telework because their child's school or place of care has been closed, and that child must be under the age of 18. Employers can request documentation to support the need for these leaves. If it's for the emergency paid sick leave, documentation about their quarantine order or from their healthcare provider. And if it's for the leave to care for a child or children, notice from the school or daycare, emails will suffice, even a notice from a government website or a newspaper. A couple of other things that we've noticed our clients have a lot of questions about is in regard to the emergency paid sick leave. It's in addition to any pre-existing leave that the employee already has accrued. So for example, if your existing sick leave policy would have allowed your employees to take 2 weeks of paid sick time, then under the new act, your employees would be entitled to a total of 4 weeks of paid sick leave. So it's in addition to any already existing leave program that you have at your business. And also a note about the expanded FMLA. If employees have already exhausted their 12-week allotment of FMLA, they are not entitled to the expanded FMLA. This expanded leave is in addition to, it's an additional reason under the FMLA. It's not additional weeks under the FMLA.
Thank you.
Right, and there are some exemptions for small businesses, businesses that have less than 50 employees, and they can have an employee that's requesting leave to care for a child or children, and they believe and they feel they can document that compliance with these leaves will jeopardize their business, can be exempt from providing these paid leaves. There's no application that's required to take this exemption, but you should make sure that you have very solid documentation that paying these leaves would have jeopardized the economic viability of your business or your ability to continue your business operations due to not having that employee present. And there are also exemptions if you are an employer that has healthcare workers or emergency service providers. You can look at dol.gov for all the specifics there. I've listed some of those positions here on the screen. And then finally, under the Act, as I mentioned a moment ago, there is 100% reimbursement for these paid leaves, and that does include any employer-provided health insurance cost. There's no payroll tax liability. Self-employed individuals can receive an equivalent credit, and if the credit exceeds what your payroll taxes would have been, you can apply for a refund. And the IRS has said they're sending accelerated payments, processing those within 2 weeks is what they're committing to.
Okay, thank you. You want to stop there? Okay.
Yes.
Any other thoughts on that?
There.
Okay, thank you. Stephen, we can start with you on the next one. So what do employers, I'm sorry.
I unfortunately have to go momentarily, but just wanted to see if there was any one last question you might have, and also, of course, to thank you. Is there anything you'd like to ask before I depart?
I don't, Stefan. If you have a final thought, or if a panelist wants to ask you something, that would be great. Anybody have any thoughts for Stefan?
I just want to say thank you so much for creating this forum, Mike. We're grateful to PBN and grateful to the fellow panelists, and you're in more than capable hands with Doris Blanchard.
Thank you so much. Very much.
Be well now.
Thanks, Stefan.
Stephen, we can start with you on the next one. So what do employers need to know from an HR legal perspective regarding navigating layoffs, furloughs, and rehiring during this process?
That's a good question. You know, different employment actions produce different employee benefit consequences. So there are a lot of things to navigate for employers around this process. In terms of layoffs or furloughs or things like that, you know, you got to worry about the employees with their benefits, 401k. You know, don't assume that coverage continues during the leave or the furlough. or automatically ends immediately upon termination of the employee. If you expand coverage to ineligible employees outside of the terms of the plan, you could face potential significant financial exposure for doing that. COBRA coverage, it must be offered to all group health plans, so you got to keep that in mind as well. Termination of a group health plan, an employee after a layoff might trigger Affordable Care Act penalties that you may need to be worried about. How employees are going to pay their monthly contributions during their leave, their COBRA contributions. That needs to be discussed and coordinated with the employee. You know, if you're terminating them or furloughing them, they're not going to have or have a very limited income stream. And so there needs to be a discussion as to how they can continue their COBRA coverage. Does your business, does a company have a severance plan policy in place that will dictate what benefits are provided? And you're going to have to make sure that you're up on that and make sure that you're consistent with that. And then with regard to 401k consequences, a reduction in force through layoff or furlough could trigger what's called a partial termination. And so you need to review hardship and other distribution provisions to make sure that you don't inadvertently or inappropriately trigger something like that, which could affect the 401k plan for the company, for the laid off employees, and for the employees that you are retaining, if you're retaining any. Those are just a few of the things that I can point out. I'm sure Kelly probably has a more exhaustive list than I do. But those are some of the things that you need to be concerned about when you're looking at a reduction in force as an employer under these circumstances.
Thanks. Kelly, did you have some more thoughts on that?
Yeah, one thing I would add to that is for your exempt employees that you employers take caution with how they conduct furloughs, not to violate the exemption under the FLSA. And if an exempt employee, if they work any time during a week, they have to be paid for the entire week. So if you are going to do furloughs with your exempt workers, that you make sure you're doing those in full week increments. That's an important consideration. Also, considering whether if you're doing a layoff or a reduction in force, whether you are subject to the WARN Act. There's federal and state level WARN Acts. Under federal, it typically requires a 60-day notice to employees. If you're doing a plant closing or a mass layoff, it's unclear whether COVID-19 is going to qualify as an unforeseeable business circumstance or natural disaster, because the DOL does not specifically list pandemics as one of the natural disasters. So I would definitely recommend you consult with counsel to see if you have to comply there. And then I would also recommend that whether you're doing a furlough, a temporary layoff, or a permanent layoff, that you consider conducting a privileged adverse impact analysis with your counsel before you undertake any of those actions, just to ensure that you're not having a disparate impact on any contingent of your workforce. Make sure that you're documenting all of your decisions with very objective criteria, and if you can provide some severance pay and get an exchange of a release of claims for that severance, that's always a good thing to help mitigate your risk.
Thank you. Any other thoughts on that? Kelly, I'd like to stick with you first on this in this next one as well. Are there some alternatives to layoffs for employers in terms of reducing payroll and employment expenses?
Yeah, definitely. We're seeing our clients look at a lot of creative solutions before they go to doing layoffs, and certainly, we would recommend furloughs before layoffs or reductions. But we're seeing a lot of our clients look at doing pay freezes and pay reductions. What I'm seeing is that many businesses are doing what we call a decelerated pay reduction structure, where they're decelerating at a higher percentage of pay, a higher pay reduction at the upper levels of their salary ranges. So maybe a 10% reduction for executives, a 5% for managers, and a 2 or 3% for the frontline employees. Reduced work schedules. Also important to note, under the CARES Act, if employers are trying to seek funding under the Paycheck Protection Program, that if they do reduce hours, reduce pay, furlough anyone, that they need to make sure they're bringing those workers back by June 30th so they can, have things in place to get those loans forgiven. We're seeing clients eliminate their incentives or reduce their bonus targets, make changes to their 401k matches. But we're also seeing businesses that with essential workers actually doing just the opposite, where it's very important to the continuity of their business to incent those workers to be retained. And so we're seeing companies look at creative things for premium pay, essential worker pay, shift differentials, retention bonuses, and we've even seen some do some 139 disaster relief payments for employees that have been directly impacted by COVID-19.
If I could add to that too, Mike, a little bit, in addition to some of the things that Kelly just mentioned, what I've seen and what I've even recommended some is terminating or at least postponing reimbursable expenses. So anytime, I mean, obviously restaurants are closed, things like that. So there's no need for like meal reimbursement for anything like that. If there was a parking stipend, if your workers are staying home, obviously you can eliminate that. I mean, there are different ways that employers have been and can be creative to eliminate expenses without actually having to lay off or furlough employees. I mean, obviously, pay decreases across the board, the way Kelly described, is certainly a way to reserve cash and save some cash. But there are other ways as well. I know, for example, my law firm, we're not doing any external CLE programs, which would cost money. We're doing the internal ones only, the ones that are free for the time being. Any expenses, cell phone stipends, things like that are being considered as either having been postponed or will be postponed as an alternative measure in the future. And some of them may not seem like a lot of money, but the collection of them adds up and can assist an employer with maybe stretching their cash a little bit longer than they had anticipated. It's a little painful for everybody, but obviously unprecedented times require certain things to happen.
Absolutely. Any other thoughts on that? Gina, I'd like to start with you first on this next one. So are all nonprofits eligible to apply for the various loan programs and incentives that are available?
Yeah, great question. And I know Mark mentioned a little something about that as well. I just want to kind of also mention that just like any businesses, nonprofits do need to look at all of the eligibility requirements for each of these programs and each incentive, just to make sure they qualify based on all eligibility requirements before moving forward. And, you know, right now, maybe more than ever, definitely our community is relying upon the services that many nonprofits offer. So it's great to see actually that nonprofits were not left out of the stimulus package. Even if folks who are with us this morning are not employed by a nonprofit, chances are pretty good that you may volunteer at one. You may even serve as a board member. And so board members, listen up, because you may be engaged right now to participate in helping your organization through managing this crisis. So in a nutshell, the employee retention credit, the first item we briefly discussed, nonprofits are eligible for that. Payroll tax deferral that we discussed, nonprofits are eligible for that. EIDL loan that Mark discussed, nonprofits are eligible for that. And PPP loan program. Mark mentioned nonprofits are eligible, limited though to 501c3 and 501c19 only. And of course, I just want to reiterate, also meeting all other eligibility requirements as well.
Okay, thank you. Any other thoughts?
Yeah, I'm not completely, because I know there's a lot of discussion about 501c4s, 501c7s, 501c6s. Clearly in the CARES Act, it's not addressed. It was silent on those. So some people seem to think silence means that they're accepted, but when we're given clear instruction, 501c3, C19, and tribal entities, I mean, I don't think there's any ambiguity there whatsoever. And even on the economic injury disaster loan side, I truly don't have a good handle as to whether or not C6, C4, and C7 are acceptable. I've sent that question forward to see if anybody will address it, and I have not received a response yet, but we're aware of the situation.
Okay, thank you. Gina, I'd like to start with you on the next one as well. So can financially or fiscally sponsored programs and projects apply for funding under any of the new loan opportunities?
So this is also a complicated question. The previous question around can nonprofits apply was also a complicated question, as Mark brought up. There are many different, say, exempt code sections under which an organization can be a nonprofit. And we're all used to hearing, of course, of the 501c3 public charities. That's our, ones that most folks are aware of. A different kind of arrangement that exists in nonprofit organizations is sometimes there's really an unincorporated group of folks. They're doing some kind of work that's in alignment with a nonprofit mission. These folks can be fiscally sponsored by a nonprofit. And what's been coming up is sometimes these projects operate in a way that look and feel pretty independent. And these projects right now are wondering, can we apply for some of these incentives on our own? Could we apply for PPP money, if you will? And we want to remind, these unincorporated, fiscally sponsored projects that they would not qualify, of course, as an unincorporated group of individuals to apply under any of these programs. So really what this is bringing up actually right now, it's bringing to light that a lot of fiscally sponsored projects really don't fully understand the nature of their relationship with their fiscal sponsor. So it's a good idea to check on that agreement, see really how it's structured. Am I an independent organization or not? If you're not, you cannot apply for any of these programs.
Any other thoughts on that? Gina, if I could just stick with nonprofits for another moment. How should nonprofits consider combining their existing restricted funding with the new credits and other opportunities now available?
This is the biggest question of the week, the day, the month, probably the year for nonprofit organizations. So here's what we know. We talked about a variety of opportunities that could be available to help businesses and nonprofits fund payroll and other costs. Nonprofits, however, are in a special position where they frequently receive contributions and grants that may be restricted to be spent on a particular purpose. They also have other sorts of grant dollars that only fund them on a reimbursement basis, so putting out money first and then getting reimbursed. So this question of how does restricted funding interact with any of the other kind of funding that nonprofits receive really is thinking about, can a nonprofit, say, claim or take advantage of that $5,000 employee retention credit that we talked about, and then also claim that $5,000 in payroll as satisfying a grantor or a funder spending requirement. So this is the complication here. And so really what we know is we need to keep track of our expenses. We talked about keeping track of the PPP loan fund expenses. We know that more guidance will likely be provided, but there are things today that we're pretty confident about. We're pretty confident that if you're considering an expenditure as eligible for forgiveness under PPP, it is not likely that you would then charge another federal source for reimbursement for that same expenditure, right? And I see Mark nodding. In nonprofit land, right, this is the double dipping question. That's what's kind of swirling around. Could I kind of get reimbursed from two different sources for the same dollar? So intuitively, there's something that doesn't seem logical about that. We have lots of other different funding sources as well that are non-federal. So really, organizations should talk to their other funders and understand what is the flexibility around the other kind of funding. So if it's foundation grants, individual contributions that are restricted, things of that nature, can we have some flexibility with those other dollars? It's a huge question for many nonprofits.
Yeah, and I think it's critical here. It's not only for nonprofits, but I also want to just kind of advise people who are getting both PPP and possibly getting an economic injury disaster loan. You can't use, the PPP is really specific for payroll, to bring back employees, and also for short-term expenses over that period, over that 8-week period. If you do get the economic injury disaster loan, you can't use that for over the 8 weeks or for short-term expenses. That has to be used for something different, and it has to be used long-term. So where you talk about you cannot double dip on the same issues, that's the same thing with both of our programs. While businesses and not-for-profits are all eligible on both sides, you got to be really careful as to how you use it, because when you go back in and you ask for forgiveness, and what does forgiveness look like? If you look at the interim final rule, the one that was put out just 2 days ago, as it began to address what forgiveness looked like, it was very specific about the things you would need in order to be able to request forgiveness. There is, including myself, there is some pretty significant confusion as to what that June 30th date really means, because and I listened to Senator Rubio this morning, and I started taking notes after I heard what the people in SBA central office said, and what they said and what Senator Rubio said were not the same thing. So he also mentioned the June 30th deadline. So I'm a little bit confused as to exactly those markers as we walk down. But Gene is absolutely correct. Be careful in how you use it, and don't use it for the same thing.
Thank you. Mark, you and Gina both and others have mentioned the same, confusion, complicated. Those words have come up a lot in our conversations here. Gina, I'm just wondering from your perspective, nonprofit.
I think that's because, Mike, I think that's because the rules, somebody said, we're flying the plane as we build it. Yep. And that's tough for people to understand. The plane is flying, we're all on the plane, and we're still building the plane as we fly along. And that's why every time we get an add to the interim final rule, I send it out to trade associations, to the state. I think most of the people on this is on my email list. I send it to all of the lenders to keep them up to date. When Treasury answers the frequently asked questions, we update on that, because we're basically getting the same information in the same time as everybody else is, and we want to make sure everybody understands it. But there have been, I've had lenders say, well, there are clarifications to not for profit, sole props, 1099s, what's a draw, what's not a draw. And, we try best to our ability to tell them, this is what you recognize, make sure that there is some kind of evidence of the draw, take the draw, divide it by 12, multiply it by 2.5. And then, thank God, Treasury came out and with a clarification and the rule that basically was exactly what we were saying, because we had some lenders saying, no, we can't do Schedule C, we cannot do anything else as it relates to sole proprietors of 1099s, where it clearly said that they were eligible. And how do you calculate it? So again, we're flying the plane and we're building it at the same time. I would say to people, hang on. We'll get more information as we move along.
No, absolutely. And Gina, I'm curious, from the perspective of nonprofits, they're sort of seem to be uniquely vulnerable. Like a lot of small businesses, they're not set up to sort through this stuff on the fly. I mean, Are they overwhelmed? I mean, what's your sense of what you're hearing from them?
So I think it's pretty consistent, likely with what a lot of small businesses are going through. And we definitely agree with Mark in that, the whole point of all of this was to deploy resources quickly. And so we understand, of course, the feds wanted to get this money out to folks. And so this is why we're operating in this kind of rapid way right now. We're advising nonprofits to think about, what stage are you in right now? Are we in application stage for something? Let's learn what we can about application stage. When we get some disbursement of funds, or when now it's time to apply some credit, let's kind of move to understanding, what do I need to do for this stage? So as Stephen mentioned, now I have a disbursement. Okay, let me start tracking expenses. Because we know, every day that goes by, there's more guidance being issued. So it's really, we'd say, a temptation to think, let me think to October when I might be looking for forgiveness or something like that. And what do I need? But it's really hard. We've got to both think long-term a little bit, but also really keep focused on what is the stage I'm in right now around navigating this information. I would say, in terms of, nonprofit specific, what we're hearing come up are things like folks trying to apply, say, for loans and such, and applications being geared towards businesses and asking questions maybe that are not applicable, like ownership and things of that nature. So nonprofits are having to be creative in how to prepare those applications so that they can be processed, but kind of having to sort of trick the application form when there were questions that are not applicable because they weren't designed for nonprofits.
Thank you. Mark, I'd like to start with you on the next question. So realistically, we've heard this a lot with people wondering, how long do I have to wait? But when can individuals and companies that have been approved for a loan but haven't got anything yet begin to see money coming their way? Is there any guidance in terms of how long you should expect to wait?
Are we talking about the PPP loans?
Well, I would start with that, but really generally any of the loan programs that are available right now. I mean, is there a wide range of waiting periods?
So let me talk about the PPP loans because in fact, as I'm working, as I'm listening to all of you, I'm also, because people are saying, can you see whether or not my PPP loan has actually been approved? And if it's been approved, then the lender has 10 days. So here's what happened. You make the application and the certification to the lender. They check your math. They then take that application and they input it into the SBA E-Tran system. And once they input it into the SBA E-Tran system, and by the way, there's still money because there's still funding. So they actually, what's called reserve funds. So the funds are reserved, which allows for the lender to then issue a loan authorization and close the loan. Loan authorizations and the notes will be determined by the lender themselves, and I know a lot of lenders have already worked on that and they're moving forward. And they have 10 days to close the loan. After closing the loan, then you immediately bring back your individuals back onto the payroll. And I had a question yesterday saying, my loan closed today. It was put in the funds were put in, this was Wednesday. It was put in my account. What do I do? And I said, well, because your employees are currently on unemployment, that will run till I think Saturday or Sunday. I said, then I would bring your employees back onto your payroll on Monday, and I would begin the 8-week period beginning Monday. I don't think anybody's saying, oh, in the middle of the week, you're going to be bringing somebody on, and it'd be too confusing from an unemployment standpoint to do that. So I think there is an orderly process that this has to be done. And I think most of the people are doing it. The lenders are trying to close these loans as quickly as possible. But just think about it. I mean, just think about the fact that if you're sitting there as a lender and you have 1,000 loans to close, and you only have 10 days from when that loan is funded to close the loan, that's a lot of work in a short period of time. And I think they're trying to space it out to make sure that they're giving everybody a fair chance. That's basically what this is about. And then I think the process goes on from there. On the issue of economic injury disaster loan, unfortunately, I have no information. I wish I did, but the last thing that I want to do is guess. That's not a good thing to do in this process. The only loans that I can see are the 58 loans that are in the system. And in that process of closing those loans is between the borrower and our Dallas office. And to be very candid with you, that's all I know. We continue to get questions about the economic injury disaster loan. We continue to send those questions over to the disaster side, or on occasion, depending upon what people say. I have sent them to the chief of staff. I've sent them to congressional affairs in Washington. I've sent them, where I think people should be reading this. And that I'll leave it at that.
Terrific. Any other thoughts on that? Okay, so this question, I'd like to open this up to everyone to give a thought or two from your area of expertise. So what other questions and issues are you hearing from both small businesses and nonprofits that maybe we haven't discussed here in detail? Now, let anyone take that on first.
Well, one thing, Mike, that I've been getting from some of my clients around the PPP loans is really what should be or what can be included as part of payroll costs. I believe under the CARES Act, payroll costs are defined simply as compensation to employees. And so there are questions, does that include benefits and other health benefits, things like that, and other compensation or other benefits that the employer provides? Because there's not a whole lot of clarity, at least that I've seen on that. My advice to clients is to err on the side of caution and only include wages as far as your compensation. Consider that as that threshold. But hopefully as this progresses and we get more clarification on it, that will be clarified as well. So that's one of them. Another issue that has come up, which I think was resolved by what is the second interim final ruling that has just come out a couple of days ago, regards partners in a partnership or members in an LLC that are filing their taxes as a partnership, that they are not eligible for PPP loans. So that was a question that was coming up, as well as to whether or not they could apply. They were applying initially, and now with this new interim final ruling, it appears that they cannot. And the question is really, and I guess maybe Mark could address this, is whether or not they could amend their applications, if it is possible to amend them to qualify differently. But those are questions that I'm getting from different employers.
Qualify differently how, Steve?
Just in terms of whether or not the partners in the partnership or the members of the LLC as employees, if they can include themselves as employees of the company and apply for the loans in that way.
So the rule is very specific on that. It depends on how the corporation and the partnership is formed. If each of the and this is addressed in the last interim final rule, by the way, because it's not, this is just not, I mean, when you have multiple partners in an LLC and a partnership that are taking draws, it's a little bit more complicated than just a regular 1099 sole prop who's just, looking at the Schedule C side of it. We keep telling people, look at line 31 of the Schedule C, and that's what you should be looking at. In this case, I'm not going to take a guess. I'd refer you to the interim final rule, but can they amend their application? Once it's approved, the amendments can happen in what we call E-Trans servicing, and there have been a number of amendments that have gone forward. As I was told by somebody today who was dealing with an E-Tran issue that I had to deal with yesterday, it's very easy to remove and go down, but at this point in time, with funds being the way they are and not knowing when they're going to run out, to amend and to increase funds is going to be a little bit difficult. So I think that's about as far as I want to go right now.
Yeah, no, and that's, as I was saying, the second interim final ruling actually did clarify some of those questions. That's what I was pointing out, that the clarification has come in. So some of those questions have been resolved through that. But more will continue to come in.
Like I said earlier, we're building the plane as we fly it.
That's right.
Thank you. Any other thoughts or issues that we haven't touched on that any of you would like to address quickly? Okay, thanks. We've got, I think, quite a few good questions from the audience. I'd like to maybe jump to those a little sooner than we had planned earlier, if that's okay with everyone. So first, Mark, maybe you could take a stab at this first, but loan recipients under PPP have to maintain an FTE account for loan forgiveness, but the way to count that is confusing. What's the timetable that you're supposed to compare FTE to? Last year, last month? Any guidance on that?
But are they talking about for application or
in order to, as in terms of being approved for the loan, you've got to maintain.
When they submit the loan, there's two calculations. They're submitting their calculation on dollars, and then there's a box that says the number of employees. And they're certifying the number of employees right on the application itself. So as you come back on the other side, you're going to have the same sets of certifications, and you're going to say the number of employees, and then you're going to give the dollar amounts and what was spent on what. It's right there on the application. So I'm a little bit perplexed at the question.
Well, I think the question seems around a timetable for how long someone has to qualify as an FTE, how long you have to maintain the number of FTEs. Is that any sense of that?
Jeannie, you want to take a shot at that?
Yeah, I'm trying to pull up my notes because, as you mentioned, this gets super particular. I've got a little bit of guidance on that. So I think that the question might relate to when I'm looking in the future for forgiveness, how do I figure out if I pass the, maintain FTE mark there?
Yeah, I think so.
And so, right? So this is what we believe today, of course, is that there'll be, we read that there's a base period that you'll use as your base count of your FTEs. And you will figure out the average number of full-time equivalent employees per month for your base period, which is February 15th, 19 to June 30th, 19. Or you can choose an alternate base period, 1/1/20 to 2/29/20. So it sounds like you go payroll by payroll for each month, figure out average FTEs, and then average the whole period. So you've got this base period of FTEs. Then you do base period FTEs for your 8-week spending period. Now, as Mark mentioned, there also is this other kind of June 30th date that's out there. This is the part that we have not yet understood fully. Is it just FTEs in your 8-week spend period that you're comparing to the base period? We know that there's also, if you can't get your FTEs up in the 8-week base period, there's a mention of you have opportunity to continue to rehire folks and get your FTE count up until June 30th. So we're not quite sure how that will work, but there are those pretty well defined right now base periods that you're using as your FTE starting point.
Okay, thank you. Okay, so this is another audience question. Our PPP loan is being processed by our bank. Before we applied for the PPP, we applied for the EDIL streamlined $10,000 advance. We've not received it. Can the $10,000 be added to the PPP loan and be funded by our SBA participating bank? And then
So,
go ahead, Mark.
Go ahead.
I was going to say there's a second part that says, additionally, our goal is to apply for the 30-year EDIL loan, but the only online application is the $10,000 advance. How can we apply for the 30-year EDIL loan?
So they actually did apply for the 30-year loan when they did that, but all they did is the box at the very end of that said, if you would like to have up to $10,000. Then click here and provide that information. So my understanding is that the agency is still going through, there's a series of, there's a process that the CFO has to go through to ensure that there's no fraud as they process those payments. And the agency made a decision that it would be $1,000 per employee. So it's likely if they only had 2 employees that it would only be $2,000 because it's set up to $10,000. And then on the other side of that, what happens if I get my PPP loan? Well, basically that's also brought over to the other side. So you add that on top of the PPP loan and you have to justify the 75-25 split based upon that as well. If you look at the interim final rule that was released on April the 2nd, it specifically addressed that in the 3rd example that it uses on page 9. It's amazing how I remember this. But on page 9, it talks about how you add in the EIDL advance that's provided under the EIDL program. But no, they don't have to go back in and reapply. They're already eligible for the long-term loan. That information is already in there. They just provided information to if they wanted the advance. I hope that helps.
Thank you. Next question. One of the fears for staff is if they are paid by an employer via PPP for 8 weeks, they come off unemployment, then at 8 weeks things are not better, they will then have to go back on unemployment and it might not be able to get back on. Any ways to alleviate that fear of not getting back on unemployment in that case?
I don't, I've been on a number of webinars that have had DLT people on that. And I think people got to look at what is happening in different compartments. And this compartment is, I get my PPP loan, I bring people back for 8 weeks. And then if something does or does not happen, that the individuals go back on unemployment, then the eligibility is still there. Remember, it's a process, and we're all going through this process together. And from my perspective, I don't think and everybody I've heard from DLT has not contradicted that. They've basically said, well, you have to deal with that at the end of that 8 weeks. And by the way, at the end of the 8 weeks, they may never have stepped foot in the business to begin with.
Right.
So, I mean, there are certain things that we have to look at. So just my opinion.
Okay. Any other thoughts on that?
Tina, do you agree with that?
Yeah, we're also advising folks to say, well, what's the stage we're in right now? We've got to deal with what we have in front of us right now. If this is an opportunity, and this is our current plan, it's as much as we know. A lot of us right now can't think 3 months in the future. Where we're used to planning out further, now it just seems like 3 months might be far, far away. And also knowing that things are changing every day. We just have to acknowledge that we're all in this unusual moment. It's uncommon that a disaster stretches out for this long. So this is why we're saying these things, is just because we have a period of disaster and we can't foresee when the disaster will end. When the disaster ends, then we've got to think about recovery. If we had a natural disaster, it'd be a quick disaster, long recovery maybe. But we're just all feeling this because we just can't see to the end, and we just have to acknowledge that we just might not be able to. We'll have to just see just those short few weeks at a time.
Thank you. What advice can any of you give special event venues that are completely shut down? The governor implied that these venues might be the last to reopen. And in all reality, the PPP program and other SBA programs can only do so much. Anything we can tell them?
I don't know. I really don't. I mean, it's very difficult. I mean, for example, I had 2 weddings between now and July. And I do know that both of those are now postponed into the indefinite future. And it's real for those venues. I mean, I think Gina said it. You know, we're looking in sections as to how we deal with this. Right now, we're looking for the next 8 weeks. I don't think anybody can really answer that question.
That's a very tough question to answer because, as you said, Mike, those if businesses are going to reopen, if the economy is going to be reopening, they are probably the last ones on the list to reopen because of the risk with groupings of people being so large at those venues. It's really, you know, unless you have an ability to you know, utilize your space for something different that won't involve those groups, which is, I can't think of anything as I'm sitting here. It's going to be really difficult for those venues to really, they're going to be hanging on the longest. And it's going to be interesting. And I don't mean that in a good way, interesting to see how it plays out in terms of how long this goes and how long they have to go without being able to utilize their services.
Yeah, Gina, you made a terrific point. Really, everybody's idea of the future has changed dramatically. You can't look more than weeks out, and makes it hard to answer long-term questions like that.
Yeah,
So
and I guess
my
just stay
retirement
tuned.
party, Michael, they'll put one person at a table.
Yes.
6 feet apart.
It doesn't sound like, Mark, you could go anywhere, so
Oh
you
yeah.
can't retire.
Mark, this next one directed to you. So any information on EIDL timetable for approval and closing?
God, ask me questions I can answer.
Well, here's the second part. Is PPP payroll forgiveness proportional? As an example, if I'm able to hire back 50% of my staff rather than 100%, will I qualify for 50% forgiveness?
You know, probably the good and the bad thing about being here for so long and being in the government for so long is I know a lot of people that I've worked with a lot of people in Washington. And I had a discussion with a friend of mine who was on one of the committees and was involved in the writing of this bill. And he knows that I've reread triple times, 10 times, 20 times the interim final rule. And he called me last night and he said, "Is there a cliff?" And I said, you know, I've read this so many times. I said, I don't see a cliff here. I don't. I mean, I see that it would be, now having said that, proportionally, if you only spent 80% on your employees, then proportionally, as the way I read it, you can only, on your ongoing business expenses, look at 80% on that side as well. You can't spend 80% of the 75 on one side and then the full 100% on the other side. That's how I read that. If anybody else reads it differently, please let me know. But I gotta believe that there is proportional forgiveness. And I think Steve was the one that said that, you know, there's recommendations on the separation of accounts, that you have a different account and somebody, and then we went to the next step was, okay, I've spent 80% of the 75%, I've spent the 80% of the 25%, and I'm left with $3,000 in that particular account. What do? I said, my reaction would be, as I'm requesting forgiveness, give the money back and then request forgiveness, then you don't have anything to deal with. And if anybody's reading it differently, let me know. I mean, and this was somebody who wrote the bill.
Okay, thank you. So we're getting this next question.
Come on, people, don't leave me hanging out there all by myself on that one.
Please go ahead.
Actually, you mentioned give the money back, and I would say I don't have an answer, but I just have more of a question and observation from lots of folks where their very question is centered around giving the money back. So if folks received, you know, say that $10,000, they're not able to spend it all on payroll or other eligible expenses. They've got, you know, that $3,000 left that you talked about. that
Yep.
really they should pay back. It's not going to be forgiven. It's not going to convert to a loan.
No,
There are
we'll
a lot
convert
of
to a
questions.
loan. No, because the way
If
the
they didn't
calculation,
have eligible expenses,
so if they didn't have eligible expenses and they didn't expend everything, then my understanding, based upon the interim final rule, is that that will convert to a loan. It will be over a 24-month period at 1%.
That's
and what
my
if they
understanding as
spent,
well.
and is it your understanding if it was spent on something other than the eligible uses? So say they didn't spend it on payroll, mortgage interest, other interest, or utilities. They paid something else.
That's a
These
different
are
question. I
so these
probably,
are the super detailed complications. I guess, what are we hearing? We're hearing all of this kind of stuff.
because they did an assertion both on the front end and the back end, I would and I'm assuming that they're continuing on in operation. I would assume that at some point in time, they can certainly assert the fact that those dollars were used for salary or other ongoing business expenses. Post that, see, the problem is we're dealing with two different things. We're dealing with the 8-week period that's specific in the interim final rule, and then we're dealing with the date, as Senator Rubio, Chairman Rubio said, June 30th, which I don't understand the correlation of the two. And so if you don't spend it in the 8 weeks, but you spend it before June 30th and everybody is back on the payroll, is it an acceptable expense? I don't know that. That's a question that's kind of hanging out there. If it's converted into a loan, the question that you asked, if it's converted into a loan for 2 years, that $3,000, does it have to be spent on those? Does it have to be spent on for which it was dispersed? My gut is because of the loan authorization in the note is going to be very specific that these monies were dispersed to cover ongoing expenses and or employee wages and benefits. I'm assuming that you can't go out and buy a car with it. So let's assume that over that next 2 years or whatever, that you do spend the $3,000. I think you can also certify to the fact you're not going to get forgiveness, but it's not going to be a loan in default, if you know what technical default, because I don't, I think sometimes we read too much into stuff. I don't think the Congress's intent on the legislation, having read the legislation, was for this to be punitive. So I think everybody's trying to work to, to work as much as we can with the small businesses. Listen, do we have all the questions, all the answers? God, no, I don't have them. And I've been on this side of the aisle for a long time. Is everything perfect? No, it's not. I mean, but at least I think together, collectively, we're all trying to walk down that road to try to figure it out in the best interest of the business community. We want to get beyond this. And I think that's really where we're at. I yield back.
Thank you. So this next question has come up a lot actually today from attendees here. It's an unemployment question. Since employees receiving unemployment right now are also receiving $600 stimulus checks, how will it work if we are approved for the PPP loan? Those employees are receiving more income not working than being on the payroll.
I'm gonna talk about what I was on two teletown halls, one with General Treasurer Seth Magaziner, the other one with the Lieutenant Governor, of which both Congressman Cicilline and Congressman Langevin were on. And I sent this out to all of the lenders this morning, saying this very issue. And I'm just going to say what was said. So if you're an employer and you offer the position back to that employee, so if you read in the bill, it says we're going to make people whole. We talk about hold harmless or safe harbor, where you're going to come back and you're going to be made whole. In yesterday's town hall with Matt Weldon from DLT, he said, then you offer the position to the employee, and the employee says, I'm not coming back. they can tell you why they're not going to come back. I'm not coming back because I'm getting $600 more or whatever it is. Then it's incumbent upon the employer to notify the Department of Labor and Training that they actually offered the position back to the individual and they have declined it. So where does it lie at that point in time? According to Matt, DLT will then reach out to the employee and say, you have been offered your position back at the same rate of pay, and you declined. And I guess they'll have a discussion and make a determination as to whether or not the employee can continue to stay on unemployment. On the other side of that, in a discussion where it was the Lieutenant Governor and it was Congressman Cicilline, and I wasn't involved. Again, I am just repeating to you what was stated in 2 different separate town halls that I believe were recorded, by the way. And the question was raised to Congressman Cicilline about the $600. And he said the intent of the legislation was not for individuals to profit from what they were doing, but to make individuals whole. And when somebody says that, I'm assuming if you made $500 a week, then the intent is to continue for you to make $500 a week. And I think that's really was when you looked at the interim final rule and they talked about restaurateurs actually looking at and providing the tips, the accuracy of tips. And if you did not have that you had to estimate based upon certain criteria was important because they wanted to make individual whole, both from an hourly rate as well as a tip when you're talking about hospitality. And I think both Congressman Cicilline and Matt, in my opinion, were abundantly clear. People can go back and they can listen to that, but that's what I understood them saying. So if somebody does say, oh, I don't want to come back because of this and $600, that's an issue between the employee and DLT, because the employer has done what their responsibility was. And I'll leave it there, and anybody wants to comment on it. I'm not making judgment. I'm just saying what was said.
Thank you. Any other thoughts on that? Right, we'll try to get to a couple more quickly here before we wrap up.
I just want to note that these people are leaving me hanging out there and not saying anything, Michael.
Well,
and we only have 4 minutes. That's why.
That's Gina. That's really good.
Well, as you said, nobody has all the answers, so that is true.
Nope, not at all.
Kelly, there's a question directly for you here. How will the FFCRA impact payroll protection if an employer would rather use approved PPP? Can they?
So they're actually they're exclusive of each other. If an employee needs to use the emergency sick leave or expanded FMLA, the employer should not be using those payroll dollars toward their loan forgiveness for their PPP loan, because those are already being credited back. So it would be double dipping to count those dollars twice. So they're exclusive of each other. Does that make sense?
It does. I think that's the question, is what would happen to one if they use the other. Right. All right, we can try to wrap up with this final question. We've received a PPP loan, but there's no way that I can use it to get my payroll high enough to equal 75% of the loan in 8 weeks. Is there any consideration to extend the 8-week time frame? Or can we use the funds after the 8 weeks for different operational costs? Do you have a sense of that?
Little bit of the question we were going back on. There's so many nuances around that, of course. And I feel like where we landed was something like, do the best you can in the 8-week period, really focused on spending on eligible expenses. And I guess to be in the mind frame of, what stage am I in right now? You know, when you're in the spend down period, you're really thinking about spending on eligible expenses, keeping track of those expenses, thinking about the 75-25. Later on, there'll be the determination of forgiveness. Forgiveness will look both at what did you spend it on and did you maintain FTEs. So also keep track of FTEs, you know, during that period of spend down. Then, as Mark mentioned, having spent in a certain way, having maintained FTEs will impact forgiveness. There's still opportunity for you to potentially retain funds as a really low interest loan. So if that makes sense, that seems to be what we know today.
I was gonna say that, Gina, is that it's, you know, what you're not using, if it doesn't apply towards forgiveness or it reduces what you can be forgiven, it becomes a low interest loan at that point. So if you can't hit that threshold for whatever reason, that doesn't, while it does affect your forgiveness, you do have that low interest loan from that point forward.
Thanks. Any other thoughts on that? Well, that brings us to a close for today's summit. On behalf of PBN, I want to thank our panelists for a very enlightening discussion this morning. You all were terrific. I also want to again thank the companies and organizations that supported today's event. The Rhode Island Foundation and Rhode Island Commerce Corporation, Insperity, and Pierce Atwood. There'll be a story of today's summit on pbn.com later this afternoon and a more extensive recap in the April 24th issue of PBN. And lastly, please save the date, Thursday, April 30th, for our next virtual summit, Business Continuity, What's Next, where we'll hear from marketing, IT, communication, HR, and behavioral health experts. We'll provide advice on keeping your business going and employees healthy during these uncertain times. Thank you all again.
Thank you.
Thank you.